Well, we're so grateful to folks for being here with us this evening. My name is Eliza Canty-Jones. I'm on staff at the Oregon Historical Society, and we are excited for tonight's program on Brackeen v. Haaland and the Indian Child Welfare Act. And we're really grateful for tonight's presenters, Erin, Dougherty, Lynch, and Beth, Wright, for bringing their expertise to all of us. The program will be recorded. We'll have an opportunity for Q&A at the end. And I have a few announcements and things before we get started. So first, we want to take a minute to talk about where we are coming from. We're actually coming from all over the place on the program this evening, but I'm here in Portland, Oregon, where the Oregon Historical Society is located. And what you see on your screen here is an image that's from our exhibition, Experience Oregon, that tells the history of Oregon. And on the screen are some of the languages that were spoken in the Pacific Northwest and have been for thousands of years. We also have a statement naming some of the peoples whose homelands and whose ancestral homelands are here in what's now Portland, Oregon. And so the Oregon Historical Society is always encouraging us to think about the fact that we're on Indigenous land, that this land is stolen land, and that it's important to learn the Indigenous history of the place wherever you are in the United States or in the Americas. We also want to give gratitude to our colleagues at EcoTrust, who have really come out with a fantastic call and set of actions, really encouraging organizations and individuals to not only do land acknowledgements, well, they don't do land acknowledgements at all, but they say go beyond a land acknowledgement and go to action. And EcoTrust offers a set of really important actions that we encourage people to think of. And there's three that are particularly germane to the work of the Oregon Historical Society. Those are on your screen now. We call on folks to challenge and reject all stereotypes about Indigenous people, to insist that your children and grandchildren are taught accurate information about the histories, cultures, and contemporary lives of Indigenous peoples in the school system, and to inform yourself about issues impacting Indigenous communities and speak up. And that's, of course, part of the reason we're all here tonight. On your screen is a graphic that's from the Tribal History Shared History curriculum. This is curriculum that the Office of Indian Education at Oregon Department of Education has worked with the 9 federally recognized tribes in Oregon to create. Tribal leaders advocated the Oregon State Legislature to require this kind of education in the Oregon school systems. And now there are tremendous resources and professional development opportunities to make sure that students across Oregon are learning tribal history, which is, of course, our shared history. So we really encourage you to make sure if you've got students in the system that their teachers are aware of these resources and bringing them in. The Oregon Historical Society respects and values tribal sovereignty. There are 9 Native nations in the state of Oregon. The flags of those nations are on display in our Experience Oregon exhibition. And it's important to note that all 9 federally recognized tribes in Oregon did file amicus briefs imploring the Supreme Court of the United States to leave the Indian Child Welfare Act in place. So we respect that leadership and appreciate that. And I want to just do a special shout out to my coworker, Isa Relas, who's the Education and Program Specialist at the Oregon Historical Society, who brought this issue to our attention and made sure that we had this program tonight, and has done a lot of research to make colleagues and the public aware of this. So thanks, Isa. One other program we have coming up at OHS that we want to let folks know about is our popular Historians in the News series. On January 10th, we'll be hosting Jeremy Surrey, who will be talking about all kinds of national news that's happening in an hour-long conversation with Dr. Christopher McKnight-Nichols. So if you have had the opportunity to see that series before, this is going to be another great one. If you haven't, we highly encourage it. The program's free. Sign up and set your calendar and enjoy that program. All right, it is my pleasure to introduce tonight's speakers. Erin Dougherty Lynch is a senior staff attorney in NARF's Anchorage, Alaska office. At NARCH, she litigates a variety of federal Indian law issues, including tribal child welfare, subsistence hunting and fishing rights, voting rights, tribal jurisdiction and sovereignty, tribal sovereign immunity, and issues related to Alaska Native communities and climate change. She leads NARF's tribal child welfare work and is heavily involved in national efforts to protect the Indian Child Welfare Act. With co-counsel, she has offered tribal amicus briefs in all 3 of the federal court challenges to the ICWA, including most recently Brackeen v. Haaland. Lynch received her JD from University of Michigan Law School and her BA from Willamette University. She grew up here in Oregon. We're excited to welcome her back virtually. Beth Margaret Wright is Pueblo of Laguna and is a staff attorney at NARF. Throughout her education and career, she's focused on advancing Indian country's next generation. Her work is inspired by a desire to uplift Indigenous joy, strength, and success. Wright devotes much of her attention to Indian boarding school healing, history, and policy, but she also tackles issues related to Indian child welfare and Indigenous methods for dispute resolution through the Indigenous Peacekeeping Initiative. Wright received a Bachelor of Arts in Economics from Syracuse University. After graduating from Syracuse, Wright combined her passions for running and working with Native youth and began work at the nonprofit Wings of America. She earned her JD from the University of New Mexico School of Law. So please join me in a big virtual welcome for our 2 panelists, and I will get their slides brought up for you. Okay, take it away, Beth and Erin.
All righty, well, thank you, everyone. It's a real honor to be here with you tonight. I am Erin Dougherty Lynch. I'm a senior staff attorney up in the NARF Alaska office, and I grew up in Newport on the Oregon coast, very close to the Confederated Tribes of Siletz Indians, and wanted to acknowledge that. And I did go to Willamette, and it's just a real joy to join you tonight. And I am joined by my colleague, Beth, who is in our Boulder office, and I'll let her introduce herself.
Hi, everyone. Thanks for having me. My name is Beth Wright, and I'm a staff attorney in our Boulder office. I'm from the Pueblo of Laguna, and I'm just grateful to be here. Thank you.
Thank you so much. All right, next slide. So I just want to, as Beth and I were working on this presentation, just set a little bit of context for NARF's work in the Indian Child Welfare Act space. And I should start actually by introducing NARF for folks who don't know. NARF is the nation's oldest and largest nonprofit law firm that is dedicated to asserting the rights of tribes and Native individuals. And NARF, I just celebrated our 52nd anniversary. And for many of the last several decades, NARF has been heavily involved in Indian Child Welfare Act work. So that has taken a lot of different forms. Some of our colleagues that preceded Beth and I at NARF drafted this resource, A Practical Guide to the Indian Child Welfare Act, which is a bench guide that state court judges around the country use. In the past, we have also represented tribes in important tribal child welfare litigation. In Alaska, that has mostly meant litigation to force the state of Alaska to give full faith and credit to tribal child support and tribal custody and tribal child welfare orders that came out of tribal courts. We've also offered technical assistance to tribes, and we monitor all of the anti-ICWA litigation that has been taking place over the last several years. And as part of that work, as was mentioned earlier, we've been involved in all of the tribal amicus briefs in the 3 cases, which I'll talk about in a little bit, that have come up in the last few years challenging ICWA. Next slide, please. So I'm at this point going to turn it over to Beth, who's going to walk through some of the history that led up to ICWA and why ICWA.
Thanks, Erin. So some of you might know ICWA already, but if you don't, ICWA was a federal law, or is a federal law that was passed in 1978 to address the alarmingly high number of children being removed from their homes, their families, and their communities by public and private child welfare agencies. So to really contextualize this high rate of removal, we have to talk about the historical child removal that Indian communities have faced for nearly 200 years. So next slide. So this is a photo of 3 children from the Pueblo of Laguna, which is in New Mexico, which is where I'm from. And in the early 1900s, 1800s, they were sent, children from all across Indian country from Alaska to New Mexico, to the Pacific Northwest, from all over the Midwest. Children were sent to Indian boarding schools across the United States. Many times children were sent as far away from home as possible, and Carlisle Indian Industrial School is sort of the epitome of the federal Indian boarding school era. There were nearly 11,000 children that were sent here, and they were sent here to really erase their Indigenous identity and make way for, the expansion of the United States. So next slide. So as I mentioned, our country has participated and facilitated in nearly 200 years of Indian child removal, and boarding schools lasted in some capacity for this long, and the effects of the boarding school era have lasted much longer. And the goal of the boarding school era was to eradicate Native people altogether. The idea was if you took their children away, you would take the next generation away from tribal nations. You would, by removing children away from their families and their communities, you would no longer have the next generation to teach traditional customs and religions and values to, and you would sort of destroy the sovereignty of the tribe itself by removing their children. Next slide. So the federal Indian boarding school era really began with federal church and state involvement sort of intertwined together, that all really targeted Indian children to forcibly remove them from their families in order to assimilate them. And it really took two federal laws to start it all. And those federal laws were the 1819 Civilization Fund Act and the Peace Policy of 1869. And so these were two federal laws that really routed federal resources and federal dollars and promoted the Indian boarding school policy in church-run and state-run and also federal-run boarding schools. And while boarding schools were initially used as conversion tactics, they were eventually used as tools to dispossess tribal nations of their lands, because the United States really had to figure out what to do about the Indian problem. There were Indian tribes and nations across the country, and to make way for settlers and the expansion of the United States, you had to figure out how to get rid of Native people and get rid of the land that they owned and lived on. So the boarding school era was all about, destroying the core of tribal communities, which was their children. Next slide. So from the federal boarding school era, we get to an era that's a little bit more modern, but still a type of Indian child removal. And so that's called the Indian Adoption Project. So what that was federal, private, and state child welfare officials came together to change state child welfare laws and policy to facilitate this adoption of Indian children. And the goal here was to reduce reservation populations and spending on boarding schools. By this era, boarding schools had become unpopular. So the United States still had to figure out a way to sort of, assimilate Native children into non-Native culture to still sort of erase that Indian identity and still attack tribal sovereignty. Next slide, please. And so with all of this history and historical, this historical era of Indian child removal, tribal nations and tribal communities really had to advocate for their communities. They had seen Indian child removal for years and years and years, and they spent years and years and years raising awareness of this problem. And by the time tribal communities really came together to advocate at the congressional level, there was estimated about 25 to 35% of all Native children were being removed or had been removed from their families and communities. And this was often without evidence of harm and without due process. So in 1974, there were Senate congressional hearings that were held where Native families and leaders and communities really told the story of what Indian child removal looked like in their communities. And Native people described children being removed without notice. They described welfare agents pressuring new mothers to give up their children. And they described how state court, there was other testimony that described how state courts really allowed this to happen, and how Native parents and Native families were never really advised of their rights or provided any legal representation when their children were being removed in this way. Children were really just taken. And what they also found was that 85% of these children were placed with non-Native families, even when tribal relatives or tribal communities were available to care for these children. There was just this massive loss of children from these Native communities, and that's what really led to Congress taking action and really needing to figure out a way to address this historical trauma and this historical Indian child removal. Next slide. And this is where I'll hand it off to Erin.
All right, well, thank you so much, Beth. And you know, Beth and I have been this last year in particular giving a lot of talks on this case and talking a lot about ICWA, and you really can't understand ICWA without understanding the history of Indian child removal. And so it's an essential piece of the story. And so just pivoting, I guess, from sort of that to the recent, relatively recent in the last few years, federal court challenges to ICWA. As Beth mentioned, the congressional hearings took place in the late 1970s. Congress passed ICWA in 1978. It is a law that is 44 years old, and only recently in the last few years have we started to see these challenges to it, claiming that it's unconstitutional. So just to kind of set the context for the lawsuits, you know, ICWA isn't really an issue that the federal courts take up very often. Child welfare cases are cases that live in tribal courts and that live in state courts for the most part. And so state courts and tribal courts are very familiar with child welfare cases, but it's not something that the federal courts generally encounter. And we've just included a couple quotes here from different cases where the Ninth Circuit it was basically acknowledging that, and Oregon and Alaska are both in the Ninth Circuit. It's a circuit that actually the majority of tribes in the country live within the boundaries of the Ninth Circuit. So it's a circuit that hears federal Indian law cases quite a bit. Prior to Brackeen, there have just been 2 United States Supreme Court cases involving ICWA, and we've listed those here. And that second one, adoptive couple v. baby girl, is really the, when people sort of ask how Brackeen, why, when did this pop up? A lot of people trace it back to this case, adoptive couple v. baby girl, excuse me, and the majority opinion from that case, which in the first sentence referenced the child's blood quantum. And that's important because, you know, when we talk about ICWA, ICWA is a law, a federal law that applies to state court cases, state cases that involve children who are either members of federally recognized tribes or eligible for membership in a tribe and have a biological parent who's an enrolled member. And I mean, there's a lot of different things you can say about the case and about ICWA. The law uses the term membership, but really what we mean by that is citizenship. The children are citizens in a federally recognized tribe, which is a sovereign that has a government-to-government relationship with the United States. And so there's nothing in ICWA that discusses blood quantum. And so it was a red flag to many when the opinion in adoptive couple came out, and in the first sentence referenced the child's blood quantum. Folks really felt like it was maybe putting a spotlight or a bit of a target on ICWA, and maybe a bit of encouragement to folks who might oppose tribes to start challenging ICWA. And that is what we did see after that opinion came out. So next slide, please. The other thing that happened too is just to build off what Beth had said in terms of the history, is ICWA was passed in 1978, but it really has been inconsistently applied in many jurisdictions. And so tribes for decades had been asking the Department of Interior to put some, to issue some regulations to provide more guidance for state courts when hearing ICWA cases. And so the United States Department of Interior did do that in 2016, and right at that time, like basically right during that process, is when we saw the first federal court case challenging ICWA. So I'm going to kind of cruise through some of this history, but we kept it in the presentation so that it was there for people to go back and reference if you'd like. But I'm going to kind of go through these slides pretty quickly, but don't feel rushed, or you'll have access to all this information later. So go ahead and next slide, please. So broadly, these are, as I said, Brackeen is the third case that we've seen. The three cases have been coordinated. It's largely the same attorneys and the same parties who are challenging ICWA. The common themes among all three cases are arguments that ICWA discriminates on the basis of race, that it commandeers the states, or that it exceeds Congress's authority. So very briefly to talk about each of those three, that first one, discrimination on the basis of race, relates to what we were just saying about blood quantum, right? So as I mentioned, ICWA is a law that applies to children who are citizens of a tribal nation, or who are eligible for citizenship and have a parent who's a biological parent who's a citizen. It has always been thought of as a law that is political in nature, because it's about the political relationship between a child and their tribal government, and the political relationship between a federally recognized tribe and the United States. There's really no blood quantum. Like I said, there's no analysis of race in the law. And so that's one of the things that's sort of unique about this case, is that they are trying to the opponents are trying to recontextualize ICWA as being thought of as race-based, which we'll talk about in a little bit. But really, the effect of that would not, if the Supreme Court goes in that direction, the effect will not just be on ICWA. That rationale could potentially undermine an enormous piece, if not all, of federal Indian law, which is the body of law that people refer to when they're talking about laws passed by Congress for the benefit of tribes. So that's sort of the main thrust of the arguments in this case, is this idea that ICWA is not political, but is instead race-based. The second argument is that it commandeers the states, and without going into commandeering, that's a relatively new constitutional theory for anyone who listened to oral argument. That was a line, there were some questions about that and how new that theory is, but it's basically this concept that there are certain things that have been left to the states that Congress cannot commandeer the states to do. And so one of our opponents' arguments is that child welfare has traditionally been left to the states, and so it's not permissible for Congress to commandeer the states on child welfare issues. And then this third argument is that it exceeds Congress's authority, and that really goes to the United States Constitution and the Indian Commerce Clause, and how that has been interpreted for literally hundreds of years. The folks who are opposing ICWA in this case are encouraging the Supreme Court to revise that understanding and greatly restrict basically Congress's authority to legislate in relation to tribes or Native people. Next slide. So actually, I meant to fix this shoot and go. Please, actually, just kind of click through this real fast. So I apologize for doing this. This is like sort of this dramatic rollout here of all the of all the like facts of the case. So what Beth and I did here is just kind of lay out from each in each step of the case who the plaintiffs are, where it was filed, and then who the amici are. And amici are folks who file friend of the court briefs. And we listed those here because it visually helps to sort of see the support for ICWA grow over the course of the case. So very briefly, the case was filed in the Northern District of Texas, in a district where there is only one judge who is doing civil cases. So if you file a case in that district, you are assured of getting that judge. Really, it's the state of Texas who's been driving this case, along with three non-native foster parents who are represented by one of the attorneys that I mentioned earlier, who has been sort of a repeat player in this litigation. Next slide, please. And you can click through this too, just to provide some context. Normally, when we talk about federal court decisions and that sort of thing, we don't really ever discuss the judge. In particular, this judge, though, just to highlight, is a judge who has an appetite or willingness, I would say, for overturning federal statutes. So it's actually, I think it's fairly rare to have a federal statute struck down on constitutional grounds. And this judge has been willing to do it a number of times in recent years. So when you hear about some of this litigation coming out of the federal district courts in Texas, ICWA is part of that context, right? Next slide, please. So the complaint that the opponents filed in this case was really what we would call like a kitchen sink complaint. It's like every possible constitutional argument you could think up in a way to challenge a federal statute. So we listed out some of them here. Next slide, please. And then here's just some information about that decision. And just a note about the presentation, when you see the yellow text, that is a hyperlink to a document. And so what we've done here is just kind of try and hyperlink to all of the different decisions in the case, as well as all of the briefs, just to make it easier if you'd like to learn more. So essentially, the district court judge found ICWA unconstitutional on a number of grounds. There was only one ground that he had denied. Very unusual, again, to have a law that's over 40 years old declared unconstitutional on multiple constitutional grounds. But that's what came out of the district court. And then after that, the case was appealed to the Fifth Circuit. So next slide, please. And I think this is, oh, here we go. So the Fifth Circuit, as I mentioned, the Ninth Circuit is, you'll see a map there. The majority of tribes in the country live in the Ninth Circuit. It's a circuit that is very familiar with tribes, very familiar with the principles of federal Indian law. Same with the 10th Circuit, actually. The Fifth Circuit is a circuit that encompasses only 3 states. There are only a handful of tribes in the Fifth Circuit, and it's just generally a circuit that encounters federal Indian law cases less frequently. It's also a circuit that has that is quite conservative, especially after the last administration. So next slide, please. Here we go again with a shoot. I'm going to take this off next time, but this is the dramatic rollout here of the Fifth Circuit briefing. So when a case is appealed from a federal district court up to the circuit court, it's heard by a panel of 3 judges on the circuit court. And so here again, you can kind of see the stats we've listed, at least in the amicus briefs, where you can see the support for ICWA growing. So it's up to 21 states now. There are over 570 federally recognized tribes in the United States. And so as you can see, 325 of them signed on to this tribal amicus brief. Members of Congress put in a brief, which was new at the time. I'll go ahead, we'll skip over to the next slide. So the panel decision from those 3 judges came down in the summer of 2019 and overturned the district court on everything. It found ICWA to be constitutional. There was a partial dissent from one of the judges, kind of questioning the issue of commandeering that I mentioned a bit ago. Next slide, please. And so then what happened was that the folks who were opposing ICWA requested an en banc rehearing of the case. And that's another one of those fancy legal terms. Oh, sorry, I think there's a few more if you want to click through. Yeah, it's hard to know. Sorry about that. An en banc rehearing by a circuit court just basically means that a party has requested the entire circuit court sit and rehear the case. In this instance, there were, I think, 16 judges that were on the panel for the rehearing. There was one Fifth Circuit judge who recused himself. Oral argument took place right before the pandemic in January 2020. And again, you see the list of amici growing, right? It's up to 26 states now, many members of Congress, 486 tribes. Next slide, please. So what we got from the en banc rehearing was, I think that's where most people started hearing about this case. It was a 315-page opinion. It was actually a bunch of opinions. Help me out, Beth. It was like 7 or 8 opinions, concurrences, that sort of thing. You know, when we got the opinion, we actually had to, with our partners, pull up, kind of make an Excel document where we put all of the 16 judges, you know, on one axis, and then all of the issues of the case on the other, and really kind of had to map out where all of the different judges came down, because it was a very fractured opinion and difficult to make your way through. But the takeaway is that the en banc court largely upheld ICWA and held that Congress does have the authority to pass ICWA, that it did not discriminate on the basis of race. There were a couple provisions of ICWA where a narrow majority held that those provisions unconstitutionally commandeered state agencies, but for the most part, ICWA was upheld. And then anytime anyone's interested in jumping into this opinion, I always have to encourage folks to note Judge Costa's opinion, which was the very last one, which basically said, none of this matters because no one has to listen to the Fifth Circuit when it comes to child welfare cases. And that's because, you know, the Fifth Circuit doesn't have any jurisdiction over authority over state courts. And so, you know, there was an issue in Alaska of, oh, do the state courts have to follow this? And the answer is no, right? It had actually a very, very limited impact, even though it was very jarring for folks who had been in the child welfare space, that any piece of ICWA had been held unconstitutional. So next slide, please. So this is a slide. Again, you know, I always say this is the slide of like what never to do on a PowerPoint slide, because it's so much dense text all at once, but it's mostly there so folks can refer to it later. This is a chart that was put together by one of our partners that basically kind of went through that opinion and noted what was upheld, what had been declared unconstitutional. And then there were some 8-to-8 splits. There was some issues where the court was equally divided. And so when that happens, it is precedential for the case, but has no precedential value beyond the case. Next slide, please. So again, maybe I got ahead of myself a little bit here, but there was very limited applicability of the case. It was controlling only in federal courts in 3 states. And remember, we said at the beginning that federal courts don't really encounter ICWA cases much, or child welfare cases. So the impact was very limited. Next slide, please. So after that, there were, as we mentioned at the beginning, 4 parties, and I should have detailed that a bit more, but it's the state of Texas, and then these 3 sets of non-native foster parents who are challenging ICWA, and then defending ICWA is the United States. The Department of Justice is required to defend federal statutes, except in very limited circumstances. And then there was a group of tribes that intervened in the case as well. So there were 4 tribes that intervened, and they were joined by the Navajo Nation. So each of the 4 groups of parties filed cert petitions with the United States Supreme Court, except for very limited circumstances. I think something to do with water masters. The United States Supreme Court does not have to take cases. They choose their docket. And so you have to file a petition with the court asking them to accept the case. I wanted to note that the United States and the intervener tribes, in filing their petition, tried to limit the issues that the Supreme Court would hear if it were to grant cert in the case, to really the issues that where ICWA had been found unconstitutional by the Fifth Circuit en banc. But the Texas and the foster parents were sort of back to the whole full kitchen sink arguments again. So next slide, please. So here, these are just to kind of build out a little bit some of the issues that we mentioned at the beginning about the issues that are present in the case. Again, mostly a slide that's there for your reference later. But again, those sort of big themes: is ICWA race-based? Does Congress have the authority to pass ICWA, or has it exceeded its authority? Does it commandeer state courts? There was an issue that didn't really get, I don't think, any discussion at oral argument, but does ICWA violate the non-delegation doctrine? Which is sort of another obscure constitutional doctrine, and the argument is that Congress cannot delegate its power to tribes. In ICWA, there's a provision of ICWA that allows tribes to alter the placement preferences that are part of ICWA, and so that's the kind of the root of that argument. But this was sort of the broad suite of issues that the court was presented with in the cert petitions. Next slide, please. So just to briefly talk about the Tribal Supreme Court project, and then I'll get back to the case. The Tribal Supreme Court project is a project that NARF runs with our partners at the National Congress of American Indians. And when a case goes up to the United States Supreme Court that involves tribes, or a federal Indian law issue, the Tribal Supreme Court project contacts the plaintiffs, or the tribal parties in the case, I should say, and offers to help coordinate the amicus briefing in the case. And so it's a project that was started in 2001 and has really, the point and purpose of it is to make sure that tribes are coming to the United States Supreme Court with a really well thought out and coordinated strategy, because the United States Supreme Court is, decisions, especially in recent years, have been quite hostile to tribes. Tribes don't often win before the court. And so this project is meant to really make sure that all of the briefs that are being submitted, aren't inadvertently making harmful arguments, and all sort of fit together very nicely to present a complete narrative to the court about what the case is about. Next slide, please. Probably a little too much information here, but the good thing about this slide is that there is a link to the Brackeen page that's on the Tribal Supreme Court Project website. And so I want to mention that because if you are interested in McGirt or any of the other big Indian law cases that you might have heard about over the last few years, all of the briefing in those cases lives on the Tribal Supreme Court Project website, and it's a really helpful place. So next slide. Sorry, go ahead and cruise through here. Well, I think we're only just going to chat for a few more minutes and then sort of pivot to questions, but I wanted to highlight, I think there might be one more row, I'm not sure here. Yeah. A lot of what, thank you. Yeah. To contextualize the case, I think it's helpful to know who is on either side, right? And so I think looking at the amicus briefs is a very helpful exercise. There's very little, very few number of amicus briefs on the side of the anti-ICWA folks. One of the things that we've been noting is that really throughout the life of this case, there's a real absence of thoughtful, discussion about best practice in child welfare. The folks who are challenging ICWA are challenging ICWA in a way that would, as I said earlier, try and tear down tribes and federal Indian law. And it's really not a case that's about ICWA. Say it bluntly, it's a case where some parties are very cynically using the well-being of Native children as an attempt to get at harming tribes. And I think that's clear when you look at some of the folks who have come in to support those arguments. It's a combination of very conservative think tanks. And then there are notably no child welfare experts who have come in support of the anti-ICWA crowd. We have the the Academy of Adoption and Assisted Reproduction Attorneys, which has been rebranded. They used to be Quad A. They threw in a brief against ICWA along with an adoption organization. And when you look at essentially what can be the trafficking of Native children or children in general, the folks who make money off of that are adoption attorneys and private adoption companies, basically. And so that crowd came in opposing ICWA. And in a minute, I'll talk about the folks who came in support of ICWA, but it's a real contrast, and I think it's worth noting. Next slide, please. So on the other side, I might have skipped a slide too, but on the other side, in terms of who came in to support ICWA, it was a real, honestly, avalanche of support. And so the first brief to note, which was referenced in the introduction, all of the tribes in Oregon signed on, all of the tribes in California signed on. Actually, all of the tribes in most states signed on. We had 497 tribes, 62 tribal and Native organizations that were nationwide, and regional organizations. We believe it's the most tribes to have ever signed on to any brief together, and it really speaks to the unity of Indian country in supporting ICWA. What we've done is just to make it helpful and easy for people to navigate is we've included a link to some of the briefing, but then there's also a link later in the presentation to a page that goes through all of the amicus briefs that were filed and lays out what each of them really focused on. In case those issues that I mentioned earlier, there's one that sort of piques your interest that you'd like to learn more about, you can look at this page and kind of find all of the briefs that are addressing that specific constitutional argument. So the tribal amicus brief is an important one if you're interested in learning more about the history that Beth was talking about, and the history of why ICWA. I would encourage you to look at the tribal Supreme Court brief because it has that history from the tribal perspective. Next slide, please. There was a brief from 23 states. All of the state briefs throughout the history of the case have been bipartisan. I think that's another thing that we are always trying to remind folks of when we talk about ICWA is that this is not a partisan issue. Both in the state brief and in the members of Congress brief, both of them were bipartisan. And it's along those lines, it's also not an issue that breaks down along what folks might think of the traditional ideological lines on the Supreme Court either. In the baby girl case, Justice Scalia, probably one of the most conservative justices to ever sit on the court, was on the side of ICWA. He believed that ICWA was an important law because he was very concerned about family rights and parents' rights and family autonomy. And so it's not, especially as the country is polarized more and more, as people say, ICWA is not that, right? ICWA is actually has wide bipartisan support. Next slide, please. I mentioned the members of Congress brief. There's also a brief from LA County, which I would like to highlight because LA County is the largest child welfare system in the country. And it is also home to the largest Native American population in the country. And so actually the tribal amicus brief and the brief from LA County go really well together if you're interested in learning more about the history that Beth was highlighting, and also the history of the relocation programs from the 1950s and 60s that were responsible for really continuing to move Native people off of their traditional homelands. Next slide, please. One of the most important briefs to be filed in all of this is, and I know we're coming up on 45 minutes, so I'll end here pretty quickly. But as I mentioned, this case, the opposition, you don't see a lot in their briefing about what is actually best practice for Native children and children in general. And so this brief is really important because it's from 27 of the nation's most well-respected child welfare, adoption, and foster care organizations, all coming in support of ICWA. And one of the things to know about ICWA is that it's a law that prioritizes kinship placement. And so people, if you listen to the opposition, they will say things that like ICWA demands certain outcomes, or ICWA demands that children are placed with tribal members or Native people. That's not really true. What ICWA prioritizes is kinship placement, which is children being placed in their extended families and in their communities. And back in 1978, as Beth was saying, and even before that, there was this concept in child welfare that it was best to move children as far away from their homes or their families as possible. The child welfare world in the last 45 years has really come around to understanding that that is not what produces the best result for children who are in care, that it's actually being grounded to their cultures and their communities and their tribes that produces best outcomes for children. And so I wanted to highlight that in this brief in particular. And if you're interested in learning more, you should really pick up this brief because it talks a lot about the data that supports that. Next slide, please. I'll cruise through these. I don't want to take up too much more of your time, but there's some very good briefing also from children's rights organizations and from folks who represent Parents Council. That Family Defense Providers brief is really a brief that kind of speaks to some of Justice Scalia's concerns in the earlier case that I mentioned. And then the American Bar Association also had an excellent brief that really had some great arguments, particular to that commandeering argument that I mentioned earlier. The state of Texas has really tried to make a big issue in this case to say, this is so unusual. Congress never does this to states. They're overreaching. And the ABA brief is great because it provides all these other examples of times when Congress has done this exact same thing in terms of regulating child welfare issues as applied to the states. Next slide, please. There's also two very, very thoughtful briefs from medical providers. So the American Academy of Pediatrics and the American Medical Association filed a brief talking about the trauma that Beth was referring to in her part of the presentation of boarding schools, and in support of ICWA as a law that provides for the preservation of family and community connections, which again produces the best outcomes for children who are in care. And then there was a brief from the American Psychological Association and their state affiliates in the 3 states that had initially challenged the case, talking again about the research-based support for ICWA. Next slide, please. I will be very, very fast. I know I was short on time, but 2 things. The former foster care brief I also wanted to highlight because, throughout the course of this case, the opposition has made a lot of claims about what they think foster children go through when they're in the system and what they think is in a child's best interest. And so this brief is a really important brief because it is from youth who were in the foster care system who speak to the importance of ICWA and how it shaped their lived experiences in the foster care system. That is one of the other things that's very unique about ICWA that I actually heard a colleague say on a presentation a few weeks ago. This colleague is a child welfare expert, and they were saying that ICWA is really the only child welfare law that we have that is based on lived experiences, right? And back to what Beth was highlighting, in the 1970s, Native people came before Congress for 4 years and told their stories about the harm that had been caused to their families and their communities by having this enormous number of children removed for no reason. And so that lived experience, that testimony prompted Congress to act. And that is an important theme in all of this, is actually listening to the people who have lived this and experienced it. And that's what that brief is meant to provide to the court, which is, I'm not sure the court very often gets briefs, amicus briefs from the parties who have lived the law that is at issue in the case. There was a brief filed by some non-native adoptive parents who were supporting ICWA. And there's also this brief called the Bradshaw brief, which was filed by the grandmother of one of the children that one of the sets of foster parents in the case were trying to adopt. And one of the themes, which we could talk about some other time, is throughout this case is sort of the misrepresentations that the opposition has made to the court about the specifics of these children's cases. And so the Bradshaw brief is really meant to address some of those narratives. Next slide, please. I think there's maybe one more slide. I can't forget all the legal experts, right? For anyone who's still hanging on. But if you're interested in a deep dive into some of the federal law, Indian law issues, the Indian law professor's brief is excellent. There's a brief from administrative and constitutional law professors, also excellent. Historians, this is the crowd, right? Who is going to love this brief. This is a really great brief, one that is new or was new at this round of briefing, that talked a lot about the traditional role over the course of history that state child welfare agencies played in accelerating the removal of Native children. All really interesting briefs with a lot of interesting historical context. And next slide, please. If you are a person who is interested in the concept of originalism, these are the briefs for you. That, as folks probably know, the current court, there are members on the current court who sort of lean towards originalist arguments, and there's been some interesting scholarship back and forth in these briefs, kind of challenging some of the misconceptions and some of the originalist arguments that have been made, but also really squarely centering federal Indian law in originalism. If you are a person who believes in foundational documents, you cannot get more foundational than treaties that predate the United States and the United States Constitution. And so these are the briefs for you if you'd like to learn more about that. Next slide, please. And then there's some other excellent briefs that are providing a variety of unique perspectives. And the National Indian Women's Resource Center brief is really interesting. The ACLU filed the brief that sort of made the arguments, as I mentioned earlier, really the answer is ICWA is not race-based, right? But the ACLU filed a brief that said, even if the court reaches this conclusion that it is race-based, it would pass heightened scrutiny, which is kind of the second step of that analysis. And then there was a brief filed by one of the senators who was in Congress at the time that ICWA was passed. So next slide, please. I think that might be it. So what's next? Oral argument was held on November 9th. It was supposed to be a little less than 2 hours. It went for a full 3 hours. And it was a very hot bench, lively court. And I hesitate to guess at all what might happen in a case, but I will say, I guess two things. One, it was very hard to sit in the court and hear some of the questions from some of the justices, but then also the statements from opposing counsel that really were rooted or seemed to be built on racist stereotypes of Native people. And the need to maybe save children from those environments. That's been a theme of the briefing from the other side. So it's, hard to sit in that space and still hear those arguments. At the same time, it did not seem like the court maybe had an appetite for really going for some of the outer limit arguments that the plaintiffs were presenting. I personally think all of their arguments are pretty outer limits because they have no foundation in law at all, or at least federal Indian law as it has been, has existed for decades, if not centuries. but who knows? I think we'll see. The court's term ends at the end of June, and so that's when we're expecting the opinion. And next slide. Right, and so that's it. So that's Beth and I, and I know I went a little bit over, so sorry about that, but happy to take questions.
No, that was truly fantastic. Thank you for taking the time to lay all that out. I'll just note, Beth, is there anything that you want to just speak to right off the bat before we open up some questions?
I don't think so. I answered one of the questions in the chat, but we're happy to expand on that a little bit more if that's necessary. But I know that there's other questions, so we might move on.
Well, I'm really interested to hear, and there's a question about what were the arguments made against ICWA. If you all could talk a little bit more about what you heard during oral arguments, sort of what you heard of from the plaintiffs and the defendants, and sort of what they were arguing about. I'm definitely hearing about tribal sovereignty, is a big part of it. Were they explicitly saying that tribal sovereignty should be nullified? Is that the purpose of this attempt? Tell us more about what you heard in those debates, in the oral arguments.
Sure, I'll start and then I'll kick it to Beth. No, so that's one thing the opposition has never done, is explicitly say they're going after tribal sovereignty. Mm-hmm. They're sort of careful in their approach, and that they are trying to frame this case as what is in the best interest of one or two children. Mm-hmm. I would note, though, that the same attorney who argued the case for the opposition for the Brackeens is an attorney who is also involved in a case in Washington State that is challenging the foundations of ICWA, which is the Indian Gaming Regulatory Act, mm-hmm. and he is employing the exact same arguments there. And so he is at a firm, Gibson Dunn, that has a history of anti-tribal litigation. And so I think, when at least tribes and advocates in this space have been learning about and thinking about and analyzing this case, as I mentioned, the arguments about ICWA being race-based and how dangerous those are, that's kind of, we suspect the end goal, right? Because if you can take a statute that a child only qualifies for if they are a citizen or eligible for citizenship, and reclassify that as race-based, really all of the laws that Congress has passed for tribes or for Native people would potentially fall subject to that same analysis, right? It's hard to see how, if ICWA is race-based, other statutes applying to tribes and Native people wouldn't be. And so there's a thought that the folks who are challenging ICWA, that it's not really about ICWA for them, right? That it's about, as I was saying, sort of tearing down the foundations of federal Indian law. And for what reasons, who knows? The firm that's involved in this case on the other side, they represent a lot of private gaming interests, which tend to have, that rub up against tribal gaming interests. A side note on that, though, most tribes in the United States don't have big gaming interests, which I think is one of the misconceptions about tribes. But it is certainly, there's, certainly some history there, right? Tribal lands around the country are house enormous amounts of natural resources. And that's another thought. If you look at some of the amicus briefs that came in opposing ICWA, a number of those same organizations are organizations who are all about tearing down federal rights. And so tearing down federal rights or protections, and who are all about, or who prioritize institutionally resource extraction, natural resource extraction. And so if you can tear down federal Indian law and diminish tribes and tribal rights and federal powers, perhaps you can get your hands on things that are shut off to you now. And so that's, none of that, though, was said at oral argument, right? At oral argument, it was a lot about, there was a lot of conversation about Congress's authority. And there was a lot of conversation about, this argument that well, about the race-based stuff. And it was really interesting. Justice Gorsuch came from the 10th Circuit. As we talked about earlier, that's a circuit that has a lot of Indian law cases. He really knows federal Indian law. So he had some very pressing and I thought very damaging questions for the folks who were opposing ICWA. There were a number of questions from Justice Jackson that on the commandeering issue that were that really I thought were kind of devastating for the state of Texas. And Justice Sotomayor, Justice Kagan also had excellent questions that were very critical of Texas and the Brackeen's positions. And then I guess the other thing I would say too is that I think the justices were really trying to sort out how ICWA works. And again, like I said at the very beginning, child welfare cases are not really in federal courts, and the child welfare systems around the country are, it's not an intuitive process, child welfare cases necessarily. And so they were sort of struggling with, not struggling, I don't mean to imply they're not brilliant something, but like working through some of the constitutional questions, but then also trying to figure out how that applied to individual cases or might apply. And I'm sorry, I can hear my 3-year-old screaming. So if you're hearing all that, sorry about that. And so Beth, I just did a lot of talking, so I'll turn it over to Beth.
Yeah, I can just jump in really quick. I think a big thing that the other side did was frame ICWA as being harmful to Indian children and Indian families. And ICWA is often thought of and known as the gold standard in child welfare generally in the United States, because ICWA is rooted in kinship placements, the idea that children of all backgrounds do better when they're placed with families and people and communities that have known them, that have loved them, that are, you know, share similarities to them. And so the other side really tried to frame ICWA as being contrary to the best interests of children, when in reality, the approach that we should take to child welfare across the board is making sure children stay in the communities that they come from. And that was a big thing that we saw on the other side in their briefing, in their arguments, and just in their the general way they spoke about the case.
Thank you. And there's a question in the Q&A about other issues of tribal sovereignty that tribes and folks who support tribal sovereignty are concerned about potentially being impacted either by this case or similar efforts. And you talked a little bit, Erin, about, you know, natural resources and that kind of thing. You know, certainly here in the Pacific Northwest, there's rights related to natural off-reservation rights related to fishing and harvesting and that kind of thing. And I'm thinking about also, just to sort of wrap this into it, you know, the federal termination era in the 1950s, where the federal government attempted to terminate sovereignty of some tribes, which was particularly devastating here in Oregon. So can you just talk a little bit about sort of what are these other issues of tribal sovereignty, and if people are relating this effort to that effort from, you know, 70 years ago now? And I, you know, guess one other thing I say is seeing, you know, ICWA as part of a series of legislations that really asserted tribal sovereignty from Congress. And there are some of those under attack as well.
Beth, would you like to go? I can follow.
Sure, I can jump in since that question was from my dad.
Oh, that's great.
But I think one thing that ICWA does, or I know one thing that ICWA does, is it allows tribes to advocate for their children in state court proceedings. And so it doesn't necessarily, and it also allows families to remove the case from state court into tribal court. So it has these provisions that sort of give the tribe you know, a right to advocate for their children, advocate for their sovereign interests in a way that a government would be allowed to do. And so ICWA, you know, is sort of has that jurisdictional type of provisions that are really important into recognizing tribes, government to government relationships, and governmental interests in the health and well-being of their tribal members.
And just to build on that a tiny bit to get to the question about the point that you made about off-reservation folks. One of the very damaging arguments, potentially very damaging arguments that the opposition is making is, without going like into the weeds on it, they're basically trying to revise the understanding of what this case Mancari stands for, which is a United States Supreme Court case from a number of years ago. And in doing that, they're making an argument that basically says, well, sure, Congress can pass this type of law, but only if it relates to, I forget the exactly how their argument was phrased, but basically only if it relates to like these internal sort of sovereign attributes of government, if you're on or near reservation. And that sounds nice and tidy. If you read their brief and you don't know anything about tribes or about federal Indian law, and you're sort of like, sure, on or near reservation seems like clear cut. That argument just by itself would be incredibly damaging. Here in Alaska, we have 229 tribes. 228 of those tribes do not have reservations. There are tribes in California, in Montana, in Virginia that do not have reservations. So right there, you would be talking about removing the protections of ICWA for over 40% of the nation's tribes and their member children. Then you also take the next step. There are tribes that have land bases, but they are far too small for all of their citizens to live on or near. It would not be possible. So then you would be sort of removing additional folks from the provisions of ICWA there. Then you also have all of the tribal citizens who live in urban areas or anywhere not on or near their nation's land base. And so that's the next step is sort of removing all of those folks from the provisions of ICWA. So it sort of builds, it's like I said, it sort of sounds maybe nice and neat and tidy, but if you actually look at what just that one argument would mean for ICWA and for Indian country, it would mean literally removing hundreds of thousands of people from benefiting from ICWA. And like I said, over 40% of the nation's tribes. There is nothing in federal Indian law that supports this concept that Congress could only legislate for folks who live on or near reservation. And any holding that said that would, as I said, sort of be devastating. So the examples I just gave were in relation to ICWA. But if you were to take that, and this is the fear in this case, and sort of draw that out, right, for how it might potentially impact all the other laws that relate to tribes, then you're talking about all of the self-determination laws. You're talking about Indian healthcare. You're talking about just this huge body of law where if you can only do it or only benefit from it if you're on or near reservation, you are removing the benefits of those laws for literally millions of Native American and Alaska Native tribal citizens who don't live on or near their reservation. Like I said, there's no support for it in federal Indian law, in the body of law that is precedent. But it's one of the things that makes this case so scary or potentially damaging for Indian country is these arguments that seem like they're discrete and only about ICWA or only about this or that, but you start to look at what the effects of those arguments would do to the body of law, and it's very jarring.
Mm-hmm. Well, we'll ask one final question, and it's basically the question that all the historians we host get asked too, which is, would you please predict the future? And there's, someone's asked, relevant to this question, what weight do you give to the fact that the court accepted review of this case rather than letting the appellate decision stand? And then also, what do you expect the ruling will look like if you care to speculate?
We've always said we're going to win this case, and we've got to manifest it. So we had an incredible, outpouring of support from so many tribal nations and leaders and other orgs that, we have so much good and on our side. So we're going to win this case.
That's perfect. Thank you very much. We appreciate that. The court took it on so that they can uphold tribal sovereignty in ICWA, and we're going to look forward to seeing that released in June of next year. I want to thank you both so much for sharing your time with us tonight, coming away from your families and whatever else you've got going on with work and your lives. We really appreciate the Native American Rights Fund for organizing, having you speaking with us here tonight and making all of those incredible resources available online. Our coworker at OHS will do a little work editing this video, and we'll have it up on our website within the next few weeks. And we'll work to get all those links organized in there on that page as well, so that folks can come back to this and refer out to it. In the meantime, we have many, many resources on ohs.org and our associated websites that have to do with tribal history and tribal sovereignty in Oregon and the Pacific Northwest. So get to know more of this. And thank you all for joining us this evening. Thanks very much, Beth and Erin.
Thank you so much.
Thank you. Thanks for your interest in ICWA.
Absolutely.